Okay. Welcome everyone. Hello, it's fantastic to have you all here. Good morning, good evening, good night. Thanks so much for being here, for sharing your time with us and for coming to participate in this fantastic event. My name is Dina Lupin. I am the director of the Global Network for Human Rights and the Environment and a lecturer at the University of Southampton School of Law. And I am very pleased to be here moderating this panel on environmental human rights defenders supporting environmental rule of law. Today, we have an exceptional panel who'll be talking about the contributions of environmental development, of environmental defenders on the development and upholding of the rule of law in environmental matters, and many of the key challenges that we need to keep our eyes on in the coming years, in the coming decades even, in protecting and supporting environmental defenders. But before I introduce the panelists, I wanted to say a couple of things. I firstly wanted to extend a heartfelt thanks to the organizers of this panel, to the organizers of this incredible 24-hour event, and to extend my congratulations to them. It's been kind of remarkable. I also wanted to encourage you all to participate, to introduce yourselves in the chat, to get to know each other, to tell us something about yourselves. Are you a legal practitioner? Are you an environmental defender? Are you a scholar? Are you brand new to this field? Have you got long experience working in environmental action? Tell us about yourselves. Say something in the chat. It would be great to get to know you, and it would be great for you to get to know each other. We really want everyone today to kind of come away with something new, a new perspective, a new insight, a new understanding of a part of the world, perhaps a new strategy that you can take away from today's panel so that you can keep engaging on this issue, because we think that the issue of supporting environmental defenders is really critical, and we want this panel to contribute to that. We want it to be part of that important conversation. So here's what we're going to do today. I'm going to introduce the panelists in a moment and just tell you where they're from and a little bit about their background. And then we're going to have a sort of evolving conversation. I'm going to kick it off by asking the panelists some questions, draw out some of the kind of high-level issues, find out a little bit about their expertise and experience, and begin to start exploring some of the challenges that we face today, but also some of the solutions that we're working with or that we should be thinking about in the future. And in the second half of our time today, we're going to open the floor and we're going to have a chance for the audience to ask questions, to raise comments, to contribute to the conversation, which I'm really looking forward to. Feel free to ask questions in the chat box, but there will also be a chance to turn on your mics and to get into the conversation yourselves. So I'm going to introduce you to our panelists. On our panel today, we have Ms. Christine Nkonge. She's the Executive Director of the Katiba Institute in Kenya. Christine is a human rights and criminal litigation lawyer and a firm advocate for due process and respect for human dignity. Our second panelist is Ms. Lisa Chamberlain. Lisa is a social justice activist, attorney, and academic. She's also the executive director of the newly established Environmental Justice Fund in South Africa. Our third panelist today is Ms. Suyang Huang, who's a legal officer with the United Nations Environmental Programme, where she works on advancement and implementation of environmental rule of law and environmental rights. Prior to joining UNEP, she worked with the UN Office of the High Commissioner for Human Rights, working on economic, social, and environment issues. We're also joined today by Ms. Romcha Twachiraratana Konkul, who's a National Human Rights Officer on Climate Change and Environment at the United Nations Office of the High Commissioner for Human Rights in Thailand. And finally, we're very pleased to have Mr. Alfred Brownwell, who's lead campaigner at Green Advocates in Liberia Alfred's also an associate research professor at Northeastern University School of Law and a visiting human rights fellow at Yale Law School. So as you can see, we have an excellent panel. I'm sure they're going to bring so much to this discussion. Our desired outcomes today are to really celebrate how far we've come in the field of environmental law over the past 4 decades, and to identify the key elements for a vision of what the environmental rule of law will look like in the future, but particularly one that is inclusive and works for everyone. And we're hoping to hear some good examples of the contributions of environmental human rights defenders to the environmental rule of defenders. So with that quick intro, I'm going to get our conversation started. I'm going to invite you all, encourage you all to please share your comments, your questions, your thoughts, your ideas in the chat box and in the Q&A function. So can I ask my panelists to join me, to turn on their cameras, and I'm going to start the questions. My first question today is for Christine. Christine, are you with us?
Yes, I am, Diana. Thank you.
Welcome. So, a good practice in Kenya in recent years has been the adoption of the new constitution in 2010 that incorporates the right to a healthy environment. That's a kind of significant step. Based on your experience, Christine, with litigation, how would you say that the country is faring in terms of making this right a reality for Kenyans, and especially for land and environmental human rights defenders?
As you have said, in 2010, Kenyans got a new constitution. And one of the things we did provide for in that constitution is the right to a clean and healthy environment. And we made this right justiciable before it was not. So this means then it becomes part of our Bill of Rights as well, and it becomes an enforceable right. And because of that, it lends itself to litigation. That's why you've noted that in the last couple of years, the organization I work with has been involved in environmental litigation. So because of that, it assists communities, activists, human rights defenders to be able to take action, judicial action, to address environmental issues. One thing also from our constitution is that it expanded the local standard. Before it was the common law, a standard whereby you had to be directly injured or affected for you to bring an action against anyone. And so because of the expanded standing, it means you don't have to be directly affected to bring a legal challenge against government or private persons who are, who are injuring the environment. You can actually institute litigation on others who cannot, in the public interest and for your own benefit. So the grounds are really broad. So in the last couple of years, we've seen substantial and consequential litigation in Kenya that has addressed the scope and breadth of the rights to a clean and healthy environment. A couple of the cases I just mentioned, maybe 3. They're quite a number. It's been 10 years now, but I'll just mention maybe 3 that I think were quite instrumental in shaping the right to a clean and healthy environment in Kenya. The first one I'll talk about is one that was mentioned in the question, Dina, and this is the one about the first proposed coal-fired power plant in Kenya. It would have been the first in Kenya and in East Africa. And a community based in Lamu. Lamu is one of the more marginalized areas in Kenya. Came together and decided they needed to challenge this government-backed project, mostly because Lamu, being fairly marginalized then, was a tourist destination. Most of them relied on tourism and fishing, artisanal fishing, traditional fishing, as the main source of livelihood for the community. So with introduction of a coal-fired power plant, of course, it would have interfered with the 2 main sources of livelihoods that they have. So this community organized together and they came together, they learned about how coal-fired power plants work. They ran an advocacy campaign called Decolonized, decolonized that targeted all aspects of this type of project, the people who are financing the project, the people who are, want to be the contractors of the project or the proponents, and the government. And together, of course, the Kenyan public, trying to tell them why they would have been opposed to this kind of energy production. And so from that kind of advocacy, together with legal support from institutes like Katiba Institute and other civil society organizations, were able to bring a challenge before the National Environment Tribunal, and the court stopped this, mostly due to lack of participation. People should have been involved because of the kind of technology that was being used. Green energy sources are available in Kenya. Coal is very polluting, as you know. And the other one, of course, was on issues of impacts on livelihoods, and the fact that the government had not made a proper assessment that this project would have not only on the livelihoods of these fishermen, but their culture. I forgot to say Lamu is a UNESCO World Heritage Site. So it's one of the best preserved Swahili settlements, and that would have been impacted as well by this kind of development. So because of that, we managed to stop the plant since 2017. And hopefully, because of targeting the financiers and everyone else involved in this project, the community seems to have passed the message. And so the project is not going on as of now. The other one I'll talk about is on the same area. And this was the construction of a deep sea. It's actually a port in Lamu, the same area, but because the sea in Lamu is not deep enough to hold big ships, the government wanted to deepen the channel. And again, interfering with the livelihood of the Lamu people. It's supposed to be 32 birds in a place where there's almost no modern industry. It's very pristine. They were to buy coal from South Africa to transport it to the coal-fired power plant, and all sorts of other things. They were going to direct all the pipelines from where Kenya's found oil in Turkana in the north to come down to Lamu in the coast for transportation. So this would have really changed the clean and healthy environment they have in Lamu. And because of that, we brought a challenge, again, based on interference with culture, livelihood, impact on the environment. The government had not done a proper environmental impact assessment. That area is also a wildlife conservancy, and there are animal parks, there's wetlands, there's all sorts of sensitive environmental features in that area as well. And we felt that the government was not doing even a bigger assessment, like a strategic environmental assessment of the bigger area to understand cumulatively what this will mean to Lamu and the environment of Lamu. And the court as well agreed with us. They stopped they actually required the environmental impact assessment to be done again. They ordered compensation for the fishermen for the time being. And it's one of those cases which is under structural interdict. It means that we'll be going back to court until we are sure that environmental concerns are taken care of. And the very last case, very quickly, it's called the Owino Uhuru case, and this involves pollution of a river from an iron smelting plant. And all these cases were brought by members of the community. They were not brought by elites in Nairobi. Elites in Nairobi might have supported in one way or another, maybe with resources, maybe with legal and maybe expert support for cases. But most of these cases were begun by the communities coming together, taking advantage of the constitution and trying to stop what was happening in their communities. And so this community as well, people started dying over a period of years, and it turned out it's because of iron pollution that was resulted from a nearby factory. This community organized and was able to go to court and with support of other actors at the national level. They were able to get a judgment recently ordering compensation, cleanup of the river, cleanup of that environment where the factory was. And so this and a number of other cases are only possible because of the fact that the 2010 Constitution has empowered citizens and human rights defenders to be able to take action where administrative measures fail. When you complain to regulatory bodies and you complain to ministerial bodies to take action and they fail to do so, maybe because of their own interest or corruption, the 2010 Constitution has enabled citizens to actually directly get redress from the courts. I don't know, I think I'll stop there.
Thanks, Christine. That's really fascinating. And I think it's kind of some powerful examples of sort of actualizing those legal tools, turning them into sort of meaningful tools for change. Ramchat, Mongolia has tabled a law on the legal status of human rights defenders, which would provide them a legal status ensuring the security of human rights defenders and establish a system for seeking justice if their rights are violated. What is the status of this law, and how can it contribute to supporting and protecting environmental human rights defenders in particular? Has it been an effective rule?
Thank you very much for this question, and thank you very much for having me joining this important conversation today. In my capacities at the UN Human Rights Office, Regional Office in Southeast Asia, I am responsible for the regional project on human rights, climate change, and the environment. And one of the main works I am responsible on is to collect good practice, good development, and monitor emblematic cases on the environmental human rights defenders in Asia. And Mongolia law on human rights defenders is one of the development we have been following. On the 1st of April 2022, the Mongolian parliament adopted a new law for human rights defenders and making it the first country in Asia to provide a framework of protection of human rights defenders. And the passing of this law is a result of a collective effort by civil society organizations, the National Human Rights Commission, human rights defenders, and other key stakeholders, including experts from the United Nations, as stated by the 2019 country visit report by the UN Special Rapporteurs on the situation of human rights defenders. Human rights defenders in Mongolia have been facing discrimination, intimidation, and harassment from doing their peaceful work, despite the Constitution of Mongolia guaranteeing the right of its citizens to conduct human rights works, and land and environmental defenders are among the most targeted group of defenders in the country, and they often face threats, harassment, and be subject of the physical violence for their role in holding state and non-state actors accountable. And this alarming situation against environmental defenders has happened around the world. In the same year, in 2019, the Human Rights Council passed a landmark resolution 4011 on EHRDs. The Council called states to adopt and implement strong and effective laws and policies. And the Council also called states to ensure that all legal provisions and their application affect human rights defenders are clearly defined, determinable, and non-retroactive in order to avoid potential abuse and to ensure the promotion and protection of human rights defenders, that they will not be criminalized. Presently, the Mongolia law on human rights defenders has been entered into force since July of last year. However, there have been some concerns raised by the civil society organizations about the implementation and the enforcement of this law. One of the concerns raised by civil society organizations, and this has been shared at the Asia Pacific Environmental Human Rights Defenders Forum we organized with UNEP last year, that the worry is about that several articles of this law could potentially undermine defenders, including is Article 7.2.1, which prohibits human rights defenders from receiving funds from any party to conduct activities deemed to harm national unity or is considered as terrorist activities, or Article 8.1.3, which prohibits defenders from defaming the honor, reputation, and fame of authors. Recently, we have seen this similar concern regarding the implementation of the law on the financial resources of defenders in many countries in Asia, like Vietnam or Thailand as well. Another issue that has been concerned and raised is the capacities of National Human Rights Commission. Following the approval of this law, there is an amendment of the law on Human Rights Commission to add a new member responsible for the matters of human rights defenders to the composition of the commission and establish a committee to protect human rights defenders. And the committee will be made of members choosing from the existing government and non-government organizations. However, one issue has been raised by civil society organizations is that the lacking of adequate budget, and they worry that this new mechanism will add burden rather than strengthen the NHRC, the commission as well. So we can see that the adoption of the law is a welcomed and critical move to ensure the safe and enabling environment for human rights defenders, but the implementation of the law and enforcement is also really crucial, and that we need to continue our work to ensure that the law can really protect and promote the work of human rights defenders.
Thanks so much for that. That's really fascinating and kind of it's sort of a good moment for the question that we have for Lisa, because in a way, Christine's answer sort of showed the power of law as a tool. And Ramchad pointed to the kind of problems that we sometimes encounter around implementation. South Africa, of course, is a country renowned for its progressive laws, for its progressive constitutionalized environmental rights, but also its kind of significant failures around implementation, its failure to secure those rights in the face of aggressive extractive growth programs. So given this gap between law and practice, should defenders keep pursuing law-based strategies of activism and resistance, such as litigation or advocacy or commenting on new draft legislation? Or is it time to think beyond the rule of law, beyond kind of battling within the framework of law? Are there other strategies defenders should be or kind of possibly already are adopting to secure their environmental rights?
I'm a lawyer, so I have to believe that law is valuable. Otherwise, I face a deep existential crisis. But in all seriousness, I do believe that law and a rights framework, in particular, continues to have a role to play. And I think some of the examples that Christine was talking about have demonstrated that quite effectively. But law must always be used in its place. And I think it's useful to reflect on why law in general or environmental rights in particular is useful. And that's often because rights can help us to equalize the power imbalances that typically exist between communities and activists on the one hand, and corporations and states on the other. And so rights translate into leverage, and they do that in a variety of different ways. Rights claiming can help to build public support, and we all know that sheer numbers and the scale of a struggle can play a very significant role in addressing power imbalance. Rights can also provide us with legal remedies and with access to courts. And of course, if you're lucky enough to live in a country with a functioning and legal system and independent judiciary, and if you're also lucky enough to access the kind of resources to get you into court in the first place, litigation can be a very powerful way to equalize power relations. And there are countless examples of communities using litigation in that way, of going to court, not really because they want to be in court, but really because they want either a corporation or a state or both to take them seriously. So that the real work of sitting down and negotiating and having conversations about where to next can begin genuinely. And of course, rights can also help us to target profit and reputation, which are the two things that matter most to the corporations that we're so often up against in environmental justice struggles. Because using the language and the narrative of rights makes it far more difficult for either governments or corporations to ignore you, as they face kind of reputational risk if they're perceived as being kind of anti-human rights in some way. And we know that money talks, at least in the kind of boardrooms where decisions affecting natural resources are often made. And one of the most exciting and effective strategies that we've seen emerging over the last few years is pressure on investors and financiers and shareholders. I think Christine spoke about that in the Lamu example. It's a strategy that's being used globally in the context of divestment from coal. And while that's not always framed as a rights-based strategy, it still relies on the laws which govern things like shareholder meetings and financing contracts and that kind of thing. But rights and law are not the be-all and end-all. And one of the most important things I think communities can do to advance environmental justice is to show not just that extractivism is harmful to people and the planet, but that alternative sustainable livelihoods work. As activists, we're often much better at pointing out problems than we are at crafting solutions, and we need to change that. In South Africa, there's a very well-known community in a place called Molobeni who have been not just resisting mining for decades, but they've been articulating and living their own form of development. So just as one example, they have a very strong ecotourism focus, and they've set up and run their own community-led NGO that runs kind of hiking and other forms of income generation in the community. And one of their slogans that's always stuck with me is "Resistance is fertile," which I think is a nice play on the much more depressing version, "Resistance is futile," and really encapsulates the idea that living sustainably, but also economically viably, is a political act. And a second critical strategy that I wanted to raise, which goes beyond the bounds of the rule of law, is self-care. Environmental activism is hard work, and Romchat was talking about some of that. It can be physically exhausting for defenders, emotionally draining, psychologically depressing, and often very dangerous as well. And so as activists and human rights defenders, it's critical that we prioritize the well-being of ourselves and the movements to which we belong. Luckily, there are many who have gone before us, and we must give gratitude to many Black feminists, and Audre Lorde and Bell Hooks spring to mind particularly, who have reminded us that self-care is not an indulgence that we squeeze in after the work has been done. It is the work. Taking care of ourselves is a political act as well, and protecting ourselves from violence to our bodies, our minds, and our spirits is not only a credible form of resistance, but an essential one. So do law and rights continue to have a place? Absolutely. Without the existence of environmental and other rights, the important rights claiming work that activists and defenders do all the time, we have no idea just how big that disjunct between law and between theory and practice would actually look. But law must always be used in conjunction with other strategies, and we have to be very strategic about how we use it, and that we actively pursue and acknowledge strategies that go beyond the rule of law.
Thanks so much, Lisa. And I think kind of what you point to as well as this binary of what is law and what isn't law is maybe a little overstated. Su-Yang, so the United Nations Environmental Programme released its first global assessment of environmental law, the environmental rule of law, in 2019. Where are we since then? What's the current situation related to civic engagement and environmental human rights defenders today from UNEP's perspective?
Thank you, Lina, and very happy to be here. And I was really impressed with the diverse presentations and the talks by the previous speakers. So let me go over a little bit more about it will be a little bit of teaser for the second environmental rule of law that's coming out later in the year. And I think like the previous speakers talked quite a lot about the laws and the practice and how the laws can work and they may not work. So I think maybe this will also give a bit factual issues, and I'm happy to present a bit of the preliminary findings that we've have and to be finalized later in the year. So first, actually want to mention that the environmental rule of law is not just about laws, and I think the speaker actually mentioned that quite well, like eloquently put it that we need other strategies. So we need the laws, but also the strong institutions that can actually implement the laws, and also the civic engagement and the participation of the people and the rights to be respected, and also the access to justice when the rights are violated. What do we do? You know, so just so wanted to build upon this environmental rule of law concept that's just not about the laws, we need everything else. The second environmental rule of law in the civic will have 4 substantive chapters similar to what we had in the first one. So we have laws and institutions chapter, and the civic engagement and the rights chapter, and the justice chapter. And as you know, they're all linked. And I want to focus on the civic engagement and the environmental defenders. And what we have done in the preparation for this report is actually like develop legal indicators and on the civic engagement and the environmental defenders. And I want to introduce like 3 indicators that are relevant for this work. The period that we did a survey is from between 2022 and 2021, and we found that 70% of the UN member states, that's 138 states out of 193, have a legal provision on the access rights. So access to information, access to participation, access to justice. So what does that mean? I think it means a lot of different things. So and there was a case in Mongolia, so that's a great case that, you know, there's a legal provision, but also sometimes it doesn't work. But 70% is a pretty high number in terms of just having the laws at the national and the sub-national level. And on the environmental defenders specifically, so we found that 34 countries have reported the killing of more than 1 killing of the murder of environmental defenders. And another survey that we have done is like also like 25% of countries, like 48 states out of like 193, have enacted the specific provisions for the environmental defenders, which will include actually Mongolia. But what does that mean? So I think it's also still a kind of mixed conclusion, because out of these 43 countries that have a legal provision specifically for environmental defenders, 10 out of these 48 countries had the environmental defenders killed in the last 2 years. So it could be a reflection of like laws reacting to the reality of the environmental defenders, or maybe laws not being implemented enough. So, and then some other key trends that we found out is so in terms of more on the civic engagement in relation to COVID-19 and also the technology. Those are the key issues in the last few years. And COVID-19, we found also the kind of mixed result. Some states like really advanced the civic engagement and the participation of the public in the environmental lawmaking and the EIAs, but also some others were lacking behind, and were not many issues, financial, also you know, infrastructure issues, because we all had to move to the Zoom-based the meetings. But there are some good practices that we found also in Nigeria and some African countries, that how they moved swiftly to the Zoom and virtual meetings, and have public participate in EIA process. And technology, and 2 things is quite conspicuous. One is social media, how a lot of defenders and the public, they are using social media. And is what is very apparent is that the social media is a great way to approach the huge number of people, and also like motivating the online. We found some cases that how this online movement has moved to also the offline the movement of defenders and the civic engagement. but also it has a lot of like digital divide issues, especially for countries in Africa and some and also like Asian countries. So that's still a very much of a barrier for the technology to will have to work on to enable the access to the technology for everyone, not just those who can afford to do it, or not those countries who have the infrastructure to do it. So lastly, I just want to mention a bit of a key developments in the environmental rule of law and the environmental human rights defenders at the global level. So I think Romchak mentioned about national human rights institutions. That's what is really great about the national human rights institutions is they have adopted the Outcome Declaration on the climate change and human rights, and also one of the provisions talk about specifically about environmental defenders. So the national human rights institutions at the global level and their organization, it's called Global Alliance for National Human Rights Institutions. They're committed in protecting. They're fully aware of the environmental defenders, and they're committed to protecting the environmental defenders. And also there's a council resolution mentioned on 40/11, which focuses on the environmental defenders. And there's another council resolution that is pretty relevant for the Kenyan case as well. And so we have the constitutional or the national level recognition of the right to healthy environment. Until last year, October, we haven't had that recognized at the global level. So the Human Rights Council in October last year, through the resolution 48/13, they've recognized the right to healthy environment, which can be applied for all and countries and everyone in everywhere. And also the UNEP at 50 political declaration refers to the environmental rule of law, and also the environmental human rights issues in the declaration. And the ARIEL Convention has adopted the rapid response mechanism, which is they will be appointing a special rapporteur in environmental defenders, if I'm not mistaken, in June this year. So it's a huge deal because we know the special rapporteur and working on human rights defenders, great, and environment and the human rights in the environment, but we haven't actually had anyone actually solely working on defenders issues. So that's a huge progress. And also the ASCAS agreement, how can we forget that? ASCAS agreement is the first regional, or actually the environmental agreement that actually refers specifically to the human rights defenders in environmental matters. So I will stop here and thank you so much for this opportunity, and happy to answer any questions later. Thank you.
Thanks, Liam. It sounds like a fascinating report, and I think we'll come back to it and talk a little bit more about it. But I think this kind of bridging of what's happening at the national and the international level is also kind of an important issue in terms of defending, looking after defenders, supporting defenders. Is Alfred with us? Alfred, hi.
Yes, I'm here.
We nice to see you. We know that plans are in the works to soon release the West African Frontline Grassroots Defenders Baseline Assessment Report, which I'm really looking forward to. Can you tell us a little bit about the report? Can you share any of the findings with us in terms of the contributions, particularly of environmental defenders, to supporting the environmental rule of law in West Africa?
Well, yes, as always, firstly, thanks to everyone for organizing such a phenomenal conversation around an issue, especially as relates to the 40th anniversary of UNEP, but also as we are going through the Stockholm plus 50. I think this conversation could not have been held at an important time. So I just want to thank all of the organizers and all of the panelists who've taken up that time to be able to make this contribution. So yes, as always in these situations, when you do an assessment, when you do a report, you want to keep it to your heart, and it's very confidential until you can come out. So actually, what I'm going to be sharing here will just be more in the form of a teaser, making sure that folks have an interest. And I hope I can use this forum as a PR event so that folks get excited about the West African Frontline Grassroots Defenders Baseline Assessment Report, and hopefully, as we launch this report, on the 16th of June, we have folks who is going to be following this process as well. So I'll just start off by saying, we'll talk about human rights and environmental defenders. I'm a defender. In late October 2019, I was forced to flee my country, Liberia. So as I speak to you today, currently I'm exiled here in the United States because of my work, working with frontline grassroots defenders and indigenous communities across Liberia who are trying to protect a vast forests in ecosystems and their indigenous home. And as a result of that, I got into some problem and I was able to leave. And so as I, traveled through my journey in exile and heading to the US, and I came here. And then I got, residency at a couple of law schools where I teach, Northeastern and then Yale. It just dawned on me, how lucky I have been, to have had friends, who were able to support my journey from across, West Africa to here to the US. And the idea was that, there are thousands of others and tens of thousands of others who, are not that lucky. And there's a need to understand exactly what situations they are going through. So with some support from a foundation, we launched a baseline assessment, documenting the experiences, the skills, the expertise, the knowledge of what we refer to as frontline defenders, grassroots defenders who were at the front line in very remote areas, who were responding to the environmental degradations, who were responding to deforestation, who are responding to the forest crisis, who are responding to the impact of the climate crisis, whether migrations and conflicts and droughts and extreme, climate or sea coast erosion. That it would be good to document those experiences, and then through a baseline, then develop tools and respond to that. And so between 2020 and 2021, we carried on the assessment and we developed a baseline assessment report. And out of that report, we carved out what we call a community-based protection protocol. We carved out what we call a policy recommendations, and we carved out what we said a strategic next step actions. So my role here today is to talk about the contributions of those defenders to the environmental rule of law processes. So, as a litigator myself and someone who spent years, representing indigenous people, when we talk about how the defenders have informed the rule of law process, it is important to understand who's been the complainants, who's been the plaintiffs. It is on whose behalf that we're pursuing those legal actions. So not just in West Africa, and not just in Africa, but across the globe, when these cases come up, these groundbreaking frontier-level environmental cases that we pursue, either through domestic courts, either through utilizing regional human rights systems, either through utilizing the UN, special procedure mandate or the UN charter processes. It is these defenders, on whose behalf we brought these cases. So just for the fact that they are at the front line and because of their responses to the impact of development and businesses that implicate their rights, they've become the one to bring these cases forward. And so there are a number of these cases all across the region. Even the case I've been involved with, the cases of the people of Buto versus the big oil palm companies in Liberia. Cases that police are brought in Kenya concerning the coal power plant, cases that police are brought in South Africa, responding to the climate crisis. The plaintiffs have been these defenders. So this is how they respond and contribute, to the development of the rule of law by us documenting their grievances and by these defenders being very brave to stand up and face the issues that affect them through a legal process. So through case law, these are coming up. So that's one aspect of how they inform that, because the self has litigants and has plaintiffs and has complainants in cases that come up to these different fora, and even sometimes to the development of soft law. So for example, there are many cases where environmental defenders are involved, where it concerns funding by multilateral development banks So there's a lot of these cases developed at that level through the non-judicial judicial grievance processes. So that's one. The other way that we've documented this process to show how these defenders have contributed to the formulation of environmental rule of law is through case studies. It's through case studies. We go into the field because most of these defenders are also indigenous people, are also local community leaders. So we go through the field to do these case studies. So there are cases to figure out, for example, the issue of their rights to land, their rights to water, their rights to habitat, how those are being impacted. We document those cases, and through those cases, what do? We present those cases as the way through which we feel that they're being harmed, we feel that they are contributing to all those processes, and then we use those case sources in the second level to develop what we call policy formulations. Policy formulations to illustrate the defenders and their case studies and the impact they are facing from businesses and development that impact their lives, that allow us to advance policy recommendations, to find a way to respond, either to mitigate or to adapt to the environmental issues that they are faced with. And through those advancement of the policy recommendations, the next tier level to which environmental defenders contribute to the environmental rule of law is how those policy recommendations then get adopted and then get processed through legislations adopted by lawmakers or through regulations adopted through administrative agencies. So you will see that that they are then contributing to all those processes. The other ways to which, and I said earlier on, that we feel that these defenders are contributing, and this is coming to our case studies, is through strategic litigations. We do a trend analysis of cases in each country and figure out what are the trending issues and how are those trending issues implicating the rights to the environment. And we document those trending issues based on those case studies, and then that contributes towards strategic litigation that then these defenders are the ones who are advancing. We also have seen some defenders who also involved in other environmental rule of law processes. So for example, because of the nature of their work and to understand what the challenges are, what the barriers are, what the impediments are, we've seen environmental defenders who have contributed to legal analysis of the existing barriers to their work. They do an assessment on the existing policy framework, on the existing legal framework, and make recommendations on how to respond to those impediments and how to respond to those barriers. So then we see environmental defenders making those clear contributions. You will see that in our baseline assessment. And there are many others I can list here to show what this is. And so in essence, when we see the advancement of environmental rights jurisprudence, let us not forget who is behind the advancement of those jurisprudence. It is environmental defenders who've been harmed. When we see the advancement of policy recommendations, let us not forget who's behind those policy recommendations. It is the environmental defenders who are behind those policy recommendations. When we see the advancement of legislation to protect the environment, let us not think for once who's behind those advancements. So today when we say that there are over 300 courts and tribunals across the world responding to the right to the environment, who is going to those tribunals? Who's bringing those cases? Who's becoming the litigant? Who's advancing the advancement of those jurisprudence? It is the environmental defenders. So how did we know that? It was on the basis of us going into the field and talking to them. Most time, especially some of us who believe that we are lawyers, we believe that we are the experts. And we have a conceptualization that those who are at the front line, who are responding to the climate crisis, are not experts. So in this situation, by interviewing them, by documenting their experiences, by documenting their skills, we're able to develop a whole body of knowledge that is now going to contribute to this process. And we hope by the 16th of June, we can release that report and you will be there in the release of that process. Thank you very much.
Can't wait to read it. I think it's going to be fascinating. Thank you for that, Alfred. That was really interesting. And I'm sorry, everyone, we're a little bit over time, so we're going to do another round of questions, but I'm going to ask all my panelists if you can keep your responses to these very full, very complex questions to kind of one quick point. If you could give us 1 minute answers instead of 5-minute answers, and I apologize for that. So Jan, if we could come back to you and come back to the second global assessment on environmental rule of law. And you talked a little bit about this, but I wonder if you could say something else about the vision for making sure laws work for the environment and for environmental human rights defenders over the next 40 years. How do we get there?
Okay, great. This question itself is a challenge to see.
I'm going to ask you to do the super fast 1 minute response to it.
Okay. So like next 40 years. So first, I've actually prepared a few things, but I think I diversify strategies on environmental defenders. So say like diversity in the response. So it's not about only like protection, but also prevention and also promotion of the activities, and also promoting the remedies mechanisms, such as the grievance mechanisms for defenders, and diversity in terms of the intersectionality of environmental defenders. They're not a homogeneous group. So there's women defenders, there's child youth defenders, and also indigenous defenders, and they are all different. They work in a different context and different circumstances. And also diversity in the awareness raising, because I think a lot of environmental defenders issues has been focused on the victimization of the environmental defenders, but that I think can change a little bit to actually really show that how they are contributing to the development and environmental integrity and the human rights. And lastly, I would say the multi-stakeholder approach. So it's just not of course, the environmental defenders themselves, also the rights holders and duty bearers, not just states, but going beyond the states, such as the businesses, because I think a lot of defenders issues are related to business activities, and also the conservation organizations and other like UN agencies and so on. So I would say diversified approach to defenders. That's it from me. Thank you.
Thank you, Siang. That is fantastic. Lisa, we know that actions are needed to ensure that environmental defenders can safely carry out their work. The question is, when we're thinking forward 40 years, how do we make sure we're not sitting in whatever this virtual space is going to look like in 40 years, looking back at sort of failures? How do we make sure we succeed in the next coming decades? Quick reply.
I've got 2 points to make, but I'll make them both quickly. Alfred has spoken so passionately about the role of defenders as the driving force. And that's, I think, the first key point is that we have to trust those most affected by environmental harm to take the lead in both designing and implementing responses to it. There are so many good reasons for doing that. They have a rich knowledge about, what's going on, what's going to work in response to it. They're highly motivated to act because they feel the impacts most acutely. Heeding their call for nothing about us without us acknowledges dignity and agency in very important ways. And there's loads of other reasons we could talk about. So really those of us that are shielded a little bit from the worst impacts of climate change and environmental destruction by some form of privilege need to constantly assess when and how we take up space, when we should rather make space for others, and how we deploy our resources in ways which constantly center activists and defenders and which defer to their leadership. And the second point is about the need to act with urgency. I've been thinking a lot recently about time, because as climate change gets worse, our window for saving the planet is closing, and we no longer have the luxury of caution. One of the best pieces of advice I've ever received was to not let excellence get in the way of good. We tend to want to perfect an idea or a strategy or campaign and conduct 1,000 scoping exercises before we embark on something. And don't get me wrong, I'm a big fan of planning and of thoughtfulness, but given the rising stakes, our appetite for risk needs to be higher, and we need to start embracing audacity. So I'll leave it there.
Thanks, Lisa. 2 excellent points. Ramchat, if I can turn to you. In the context of the UN's common agenda and call to action for human rights, how does the international community ensure that good practice is applied equally in different parts of the world where human rights defenders are under attack? The speed version, please.
I will try to answer the difficult question in 1 minute. I think sharing the good practice and experience from different regions is very important. Like we are learning experience from Latin America and Europe colleagues to have the similar regional framework on the right to the healthy environment, like ESCASU and Aarhus Convention in Southeast Asia region. Better policies and law from the developing countries. As we all know, a lot of defenders in developing countries has been under seriously attack, like the EU directive on the corporate sustainable due diligence, which could be the good entry point to have the better protection of defenders in their global value chain. Unfortunately, the draft EU Commission has not really include any measure for the protection and promotion of the work of human rights defenders, and we have to continue working on that. Continue leadership from the champions and countries in the global or regional dialogue on behalf of environmental human rights defenders. For example, Sweden organized the high-level side event at the Human Rights Council on environmental human rights defenders, and as a result of that, they delivered a joint statement signed by 60 countries to advocate on behalf of environmental human rights defenders to bring this issue in front of the Human Rights Council. And lastly, the adoption of General Assembly, the recognition of the right to the healthy environment at the earliest convenience, because the General Assembly resolution on the right to the healthy environment would reinforce the urgency of action to implement the rights and the work of human rights defenders. Quickly from me. Thank you.
Thank you so much. Christine, with Kenya's general election around the corner, in your review, what are the key elements, or maybe just the bare minimum things that the incoming government must pursue to ensure that the contributions of environmental defenders are adequately integrated into environmental decision-making?
Okay. So I think at a bare minimum for Kenya, because Kenya generally has good laws, is just, to implement those laws. By and large, if that was done well, then I think we would be able to protect human rights defenders better. But other than that, would need meaningful and effective participation in laws, policies, and plan making by human rights defenders, communities, and indigenous groups, and marginalized or minority groups affected by government and other projects. And this kind of participation should not only be at the tail end, it should be at conception stage, at planning and implementation stage. As Lisa said, if communities are involved at very early stages of these plans, they are able to co-create solutions most of the time, which have better impact on the environment if final decisions are imposed upon them at the tail end. We thought also, for me, another effective way of ensuring their concerns, human rights defenders' concerns, make it up the pipeline to the decision makers and the duty bearers, is to have complaints mechanisms throughout the lives of these projects that are culturally sensitive, because then they have a way of filtering that information to actually change, revise, or cancel plans, even as projects go on. But most of these relate to audience, ability to give audience and to listen and to take action based on that. So I'll leave it at that.
Thanks so much. I think there's a kind of really important theme emerging here about kind of defender-led action at the international and national level, the importance of creating platforms to speak, but also of learning to hear. Alfred, Green Advocates is supporting efforts within Africa to bring countries closer to a regional level agreement on procedural rights in environmental law. How would such an agreement improve the situation for environmental human rights defenders on the continent, since we're sort of thinking about international and national level defender-led processes? And also a quick one, please, but everyone's done a very good job of clawing back.
Absolutely. So I hope I can stay within the sort of 1 minute that you put so much in there. Is an entirely new process. But, you know, like I said earlier on, who is the expert here? It is the defenders, and was placed in front and central to this issue. So even though you're saying that Green Africa is leading this process, the idea of a regional agreement, a framework to respond to the environmental impact came out of the baseline assessment, informed by the baseline assessment. And then a couple of different key studies came up. And so now across the region, because of the mandate from the baseline assessment and the mandate from the conference that was, the post-conference that was held, we have now convened some key studies, informed by a couple of few key studies. And now across the region, civil society is organizing and building a momentum to advance this whole idea of a regional environmental right legal framework. And part of that is to respond to how the leaders across the region are opening up Africa for this free trade area that's going to attract trillions of dollars of investment. Already defenders are complaining and seeing the impact of existing foreign direct investment on their life. Now it's going to be opened up to this massive onslaught of foreign direct investment, and the need for the environmental and social safeguard. Thus, the idea for, in Africa, the environmental right legal framework. So how would this respond to that? So I'll just mention 4 or 5 different ways. One, a potential future agreement would be a useful tool to unpack opportunities for national and regional level actions and the protection of rights, especially for countries that lack the laws and policies. Secondly, having a binding agreement will push the political will and elevate the debate to another level. For instance, sparking a debate at the regional bodies such as ECOWAS or SADC will help to create a better understanding of the environmental rights and form greater collaboration and strengthening relationship within countries. Also, this could support strategic litigation cases filed in Africa. This will also be used as an example of the environmental violation by multilateral cooperation in Africa. A binding agreement will give direction on how to align the standard of practice with regional agreement. It will also help to synthesize all the standards and guides countries with no environmental laws, as well as I said earlier on. And it will help to strengthen cases and access right and ease the struggle with regional projects, such as the East African crude pipeline, where there were different legal and policy contexts. This will also be a response to the free trade areas, like I said, having a continental-wide agreement. And the regional agreement will promote an African-led process on environmental rights. I will stop here for a while because I wish I could say more. I'm very limited by time. And if there's any other question, I'll respond to that. Thank you very much for this opportunity.
Thank you, Alfred, and I hope we can come back to this in the question time. Thank you to all of the panelists. Apologies that you had to say so much in such a short amount of time. Well done for doing it so eloquently and brilliantly. I want to now give the floor to Paul Mulindwa and Emma Pagliarusco, who are just going to kind of give an intervention. Paul, if you're there, if I can call on you first. I wonder if you could share your reflections on the discussion that we've just had. Do you see any additional elements from your kind of advocacy experiences with Civicus in Africa that you think could add to this conversation, that you think need to be mentioned? Paul, you're muted.
Sorry, thank you very much, Lina, for this session and important key component in our discussion on the continent and globally at large. I work with Civicus as advocacy and campaigns lead for Africa, but my work cuts across to the globe. If time had allowed, for sure I would have given my space to Fred, because Alfred and I share many ideas alike. And yes, as he alluded to, the experts in the room are the environmental and land defenders who are mobilizing and demanding critical issues from their governments, from their state parties in terms of environmental justice and climate change. Civil society organizations are also ensuring that the needs of excluded and adversely affected populations are brought to the floor. So the human rights defenders, the activists are out there to create a space for where citizens and the marginalized communities can participate. At the national level and the local levels, these activists who land defenders, indigenous peoples are already alluded to, are all at the front line. And they continue to demand a lot from their stakeholders, both state and non-state actors. And this activism has changed, has achieved tremendous impacts, including pushing for policy and legislative reform, forcing the media and governments, politicians to acknowledge the environmental issues, climate change. And in some countries, you can, for instance, take of Uganda, having now like climate change, the environmental policies have been, energized and bolted. So as the climate and environmental issues intensify, for sure we need the contribution of these defenders at all the fronts. And we need to know that, but they meet profound barriers, as I think Lisa noted, environmental defending is a hard work. It is a traumatizing, it is a risky, it is a deadly, as civic freedoms are being systematically and violated all over. But what exactly, just 2 or 3 points that these environmental activists are doing, in addition to strategic litigation, studies and community mobilization and policy analysis, they are creating spaces to ensure that the local national discourses around the environment are brought to the fore, and they can share strategies and tools. This involves many things, but particularly creating linkages to map activist strategies and then link with the governments and the different actors. Harmonizing methodologies and platforms in terms of tracking who is persecuted, who is harassed, who is in problems in terms of defending environment and climate change. And my last point on this would be they are deepening and mapping digital and physical security trainings and the different capacity building activities. But it would not be good just highlight 2 or 3 points on the challenges. There is increasingly control of public space restrictions of the right to protest, especially when the defenders come to express their issues. We've seen this in different countries, not only in Africa. We see this in Canada, where around 14 activists were actually detained in 2019. We see this in South Africa here, with the many human rights defenders being implicated. Then there is stigmatization and promotion of hate speech. This is always a trend, especially by the politicians. We saw it in Brazil, where the president Bolsonaro, during his campaign, said that it was actually the human rights defenders who were alighting the Amazon. In Guatemala, the president was Morales, who said that they are criminals. And immediately after his declaration, we saw how many human rights defenders were killed. And then in South Africa here, just last week, we were counting up to 23 human rights defenders killed in one community for defending their land. There is also finally judicialization as a tool to repress environmental activism. If time allows, we can come back for recommendations and the way forward. Thank you very much.
Thanks so much, Paul. I think sort of contributing very sort of important points there about kind of being in a space of backlash in many ways against the sort of progress and achievements of defenders. Emma, Emma's from Youth and Environment Europe. Over the last 4 decades, there's been growing participation in environmental law matters from children, from youth activists. Can you talk to us a little bit about some of the strategies and approaches that youth activists particularly are pursuing to address governance and implementation gaps in regard to the environmental rule of law as youth defenders?
Yes, so first of all, thank you very much to all the panelists and for the very enlightening conversation. So as said, as member of Youth and Environment Europe, which is the largest independent European network of environmental youth organizations, I will spend a few words on the role of youth in enhancing the environmental rule of law. So we have to start considering youth, young people and children as the generation of today and not the generation of tomorrow. And this is the starting point to acknowledging that that the role of youth and children in enhancing environmental law is not only as rights holders, but stakeholders mainly. It is true that over the last decades, there has been growing participation in environmental law matters from young people and youth-led environmental organizations because of the growing global concern on climate change. In this scenario, young people, through collective work within youth-led organizations, for example, focusing on environmental-related policies and laws, constantly address governance and implementation gaps. Through activities of advocating for ambitious, inclusive action to address climate change, raising awareness within the international and national arena, for more stringent environmental laws, for example, by organizing large events and including as many young people as possible, and as building capacity among these young people while increasing the level of knowledge in international environmental law, national environmental law, and European environmental law, or all the other regional environmental laws in general. From our side, Youth and Environment Europe, more concretely, within the organization, we have different working groups, one of which is the environmental law working groups that constantly works on activities for raising awareness and building capacity by, for example, releasing articles, handbooks, and other publications that render environmental law more accessible to young people, because most of the times it seems so distant, so far away from our everyday life that we don't know where to start from. We don't have the knowledge, we don't have the right approach to actually engage. So the first action is to actually increase knowledge on this. We also are organizing a series of interactive workshops to talk about public participation opportunities, climate litigation, and international environmental law. But also more generally, we support member organizations and contribute to enlarge the network, reaching all young people with an eye to the most vulnerable, and with an eye to our approach is to reach all the young people as possible, not only those that study environmental law, for example, or those that study environmental policy. So to sum up, when youth is engaged in environmental actions, is contributing actively to stopping the repercussion of environmental degradation on the future, and thus they enhance intergenerational equity. Up to now, if I can spend a few words of where we are now from our youth perspective, the UN arena is moving forward, forward and towards a more just future, if you want, under one theoretical perspective, which is, for example, represented by the recognition of the right to a healthy environment last October. But some steps have to be taken under the implementation side, which is considering young people as crucial stakeholders of today and not of tomorrow. The gaps we have highlighted is non-permanent non-permanent participation from young people into environmental law decision making, and are still blurred and not strong enough interlink between environmental law and human rights law, which has been enhanced through for example, the recognition of the right to the environment, but which has to be strengthened more and more. We have to realize that today and not tomorrow, children are dying because of climate change, and young people are actually in the position of making the change today. So we are in the position of actually doing something, but we demand for more inclusive and permanent capacity, which within the environmental law decision making, because I think that we can actually contribute with an eye on the future, which is actually needed, while also considering all the gaps of the present. So yeah.
Thank you, Emma. I think that was really fascinating to learn about their strategies. I think it's kind of also, it points to the sort of importance of seeing kind of youth as experts, not just as kind of rights holders, as you say, but also thinking about the kind of intersectionality and defenders. You know, defenders are defenders, but they are also all the other things they are. They are also children, or they are women, or they are sort of they sort of live in a variety of identities. And I think that's an important thing to bear in mind. Thank you to everyone. We're kind of nearly back on schedule, and we now have some time for Q&A. We have a couple of questions in the Q&A section, and I will ask those now. But I also wanted to encourage you to please turn on your mics to ask each other questions. I wanted to say that the panelists are also welcome to pose questions to each other. I think it's been a fascinating panel, and I think that this is the time to sort of have a discussion. So I'm going to start with a question in the Q&A. And the question, I think maybe it could be one for Alfred or Suyang. Are there any efforts to put together a universally acceptable framework to be adopted by all countries for the protection of environmental rights defenders? That question comes from Gabriela Camara.
So I will speak more to what we are currently working on in Liberia, in West Africa and across Africa as well. And to say that, like I said, that is gerrymandered by the defenders because it's based upon an assessment that we did, but also a follow-up conference and also different case studies. But that is also informed by some of the existing international processes. So for example, there's Aarhus, right? So the Aarhus Convention informed what we are going on. Mm-hmm. But don't also forget that recently we have the ESCAZU, right? South American, Latin American countries is informing that process. So we can definitely see the evolution of hopefully a global process. Right now, we're seeing it at regional levels. So there's the South American ESCAZU, there's Aarhus in Europe, and now hopefully, if we can have an African environmental right legal framework, we believe that will provide some protection. Because on our ESCAZU, for example, and this is what we're also trying to tailor in Africa, that is going to be specific protection for the environmental and human rights defenders across the continent. Because that's why we're trying to build a safeguard. But even going much more further to ensure that they are front and then they are central. So you're seeing that. But also, if you look at some of the conversation going on for putting into place this transnational treaty on corporate transnational treaty that is going on now at the level of the UN, there's a couple of provisions that also speak specifically to the issue of human rights defenders as well. So it is, we are not yet there, but I believe that if we have these different sub-regional processes, eventually that might coalesce into one global universal treaty to protect defenders. And here where this is important, and most time, you know, and you hear folks saying, well, many folks don't even know that they're defenders. We've seen that in our baseline assessment. Frontline defenders don't even know they are defenders. These are the people who are, like I said earlier, responding to the climate crisis. They are the closest to the impact. But not only are they closest to the impact, they are the most vulnerable. They are the most impacted. Not only that, but they also have the solutions. I said earlier on, the cases we bring, who's informing the jurisprudence? Who's informing the policy framework? Who's informing the legislation? It is them. Not only that, what I also want to say is that these are our first responders. They are our firewall. If we don't secure that firewall and there's a breach of that firewall, all of us are going to then get affected. That's why I think the urgency is now for the world to move forward to put in place a framework for the protection of environmental defenders across the globe. We are not doing so, we undermine that firewall and ensuring that the first responder won't be able to act in the timely manner to protect all of us.
Thanks, Alfred. I think this point about thinking about the sort of emergence of international law in a more iterative sort of bottom-up way. So there's kind of the emergence of regional systems that refer to each other and develop together a kind of international standard, I think is really important, but also this urgency that's sort of come up from lots of the presenters, I think is kind of critical. That there needs to be sort of evolutive processes happening everywhere together all the time, using all the tools we have simultaneously and right now, I think is very important. Soo-Young, did you want to add something to that?
Yeah, I'll be very quick. Thanks so much for this question. So I think everything that Alfred mentioned about the regional developments, and that's really great. So there's a process that is in place at the recognition of the right to healthy environment. I mentioned that was recognized by the Council last year, but you know this is one way to go about actually recognizing the environmental rights for everyone, including the environmental defenders. And it's actually should go to the GA. The GA, the UN General Assembly, to recognize that right. There will be like one way actually to capture all these issues that we're actually addressing at the global level. And the resolution will not have, it's not legally binding, but it will have a huge impact at the global level, but also the European Court of Human Rights and the European Convention and the implementation of the ESCAS agreement. So I think actually the global recognition of the right to healthy environment by the UN General Assembly, that will be universal, and that will be also applying for everyone, and all the countries will be a crucial step in this regard. Thank you.
Thanks, Soo-Young. I wonder if I could ask a question that sort of comes from Paul's point about sort of what we're seeing with Bolsonaro. And, you know, there are in some ways, we're seeing this kind of incredible progress and movement in the development of instruments internationally, regionally, locally, but we're also seeing backlash against environmental progress. We're seeing backlash against efforts to protect defenders. If we're thinking about a kind of 40-year timeline, how do we anticipate, how do we kind of deal with this backlash in some ways, and how do we protect defenders from the pushback that comes after an enormously progressive step like the recognition of the right to a healthy environment that'll hopefully happen at the UNGA?
Okay,
that's a hard question. Sorry.
that's a very, very tough question, but I think so I try to actually sort of like stay positive. Like I know it's like kind of like dooming situation for a lot of defenders, but when we actually think about like a step back like 10 years ago, we didn't actually have the term the environmental human rights defenders, and defenders themselves, they weren't aware they're human rights defenders. So you can actually see over the last 10 years, there has been a huge progress. And, you know, we have some backlashes at the country level or the different levels, but I think the progress has been made you know, constantly. So I think we'll have to believe in that. And And just one example that I want to just give is the recognition of the right to water by the GA about 10 years ago. So that is an example that we give everyone. So does it matter that the things bad things happen and we regress, and but how are you making the progress? So that recognition of the right to water had a huge impact on the people's lives in access to water. So you can actually see that as a data shows that the resolution had an impact on people's lives in the access to clean and clean water. So we really think that the step forward is the recognition of the right to healthy environment, and then we build upon, we implement it in a complementary to other like regional and national mechanisms.
Thanks, Sue-Yang. Thank you. I see your hand, Lisa.
Thanks, Dina. I just wanted to chip in on the question of what we can do in cases of anticipated backlash. Because I think one of the things that it's incredibly useful to do in the somewhat rare circumstance where we can anticipate backlash is to try and preempt it by naming it. So if we're passing a new law at domestic or at international level, to get very credible kind of institutions to very publicly say, it can be that in response to the passing of laws like this, there can be backlash against human rights defenders, which can take the following forms. This is unacceptable because A, B, and C. It is illegal because A, B, and C. The consequences of this can include A, B, and C. So that when the backlash then, firstly, you try and then, use that as a deterrent. But then when the backlash actually happens, you've got a much more kind of immediate response because defenders are sort of prepared. They have statements like that to use as leverage. But I think it can send a very strong message to because it's much more difficult for a corporation to then target a defender when a United Nations Special Rapporteur has called them on it before they've even done it.
Excellent, thank you. Those are, I think, both great answers. We have a question here about the African Charter on Human and People's Rights that I'm going to expand a little and pose to Alfred, Christine, and Lisa. The question is, the African Charter on Human and People's Rights recognizes the right to environment, but enforcement of this right has been a huge challenge. What more can we do as a continent to ensure that African leaders and businesses respect and ensure this right? And I want to extend that question a little bit. Thanks for that great question. And I'm going to ask Alfred to answer it, but also extend it a little bit to Lisa and Christine to ask about how at the national level there can be more done to kind of integrate African level instruments and solutions. How does the right to environment in the African Charter play a role in defender advocacy in South Africa and Kenya in particular? Over to you, Alfred.
So thank you very much. This reminds me of another hat that I wear here in the US. As a lecturer of environmental and human rights law, I have a course that I teach at Northeast University School of Law, and this is the question my students always ask me, like, Professor Brownell, there's no teeth into the law, there's no enforcement, there's no compliance, so how are we going to enforce these different issues? And, so what we've seen, and I think before the last speakers talk about, how this is evolving. A lot of this, like you see, the enforcement and compliance of the right, to the environment is based upon what public interest lawyers like myself, because I call myself an activist lawyer, who are at the frontiers, who are building up the cases, the challenges, and going to court and trying to enforce compliance, who are trying to look at what folks would call the realm of soft law and playing some magic, wordsmithing that, and seeing how those soft law are evolving to the point where they are going to get hardened. So you might figure something like, okay, there's a right to the environment, and you might test that. And you see that being tested in different levels. So look at the range of climate litigation going across the globe, right? lawyers are trying to test that whole question of the right to the environment, the whole question of intergenerational equity and responsibilities, the responsibility of state, the duty to protect. So at different venue, at different fora, this is what we are doing across West Africa as well with the network I'm part of. So you test these issues, you say, yes, what the UN providers are, you can go to domestic court and test them and see how it's going to respond. You can go to regional human rights system and test them. You can go to the UN system and test them. And at different levels, you can see the evolution. I'll just give an example, especially for those who are here from the US, like a US audience. So look at first the case in the Netherlands, the Agrenda case. Look at the Juliana case, right? A first step, a West in a do where a judge said, in my reasoned opinion, a free and ordered society to exist, you must have a livable climate. There's no right to the environment in the US Constitution, but a judge was brave enough to make those pronouncements, right? By one judge. It went up to the circuit and there was one dissent by the judge. So there is a step in the door. So lawyers are on the frontiers challenging these issues and trying to identify where are the areas to which they can advance those. Secondly, in the area of policy and legislations, the standard set, the principle set, we're now seeing the whole right to the environment build up on some of the principles that was announced from Stockholm, also announced in Rio. We hear about the precautionary principles, come about differential responsibilities, intergenerational equity. All of these are finding themselves into existing legislation and existing policies. So we can see in combination, the whole idea of a right to the environment is being advanced based upon how the different species are either forming legislation or policy work, but also informing strategic litigation. And through this, we see soft law, which in its realm could be unenforceable, being hardened through these different existing processes. And this has been my response to my students whenever these questions are asked. So it's the full range of the arsenal that different defenders and public interest lawyers are deploying to advance the right to the environment. To the extent now that we have, a UN declaration and hopefully a UN General Assembly declaration that will advance these rights. So you can see a progressive development of this concept going forward.
Thank you, Alfred. Thanks very much. Christine, do you want to weigh in on this question a little bit and think a little bit maybe about the African Charter at a sort of national level?
I don't think there's much I can add to what Alfred has said. I mean, that's an excellent answer of how we as lawyers, I'm also a lawyer, integrate, governmental commitments at the regional and global level, human rights commitments in our work in the courts, actually look at both hard law and soft law in litigating and ensuring the courts that are going to be deciding these cases have those materials, but it's not only ensuring that the lawyers, judges who are hearing the cases have those materials, but actually working with judicial training institutes to train judges and other judicial officers on a human rights-based approach to determining land and environmental matters, because sometimes they can be really complex. But other than that, also as advocates, what we are finding is that we need to always have a sort of interdisciplinary approach to litigating environmental cases. So we tend to borrow very heavily from things happening at the regional level and international level, and now bringing them at the national level, including strategies. So at that time, you'll find that we'll reach out to lawyers in Brazil or in Mexico or in Spain, because people have different strategies that they are doing, or even Jamaica, depending on the issue that you're dealing with, and asking them, how did you sharing best practices and experience sharing in terms of both legal strategy, advocacy, and other engagements at the international level. And also because in Africa, we also have East Africa, we have also the East African Court of Justice is trying to find out, for example, the crude oil pipeline and the fact that we are countries that share natural resources, lakes, and others. So one impact in one country will definitely be felt across the border. So whenever we have lawyers in Uganda going to court on some of these issues, lawyers from Kenya will come in and try to give in expertise on what worked from their end, and so forth and so on. So in that way, we sort of try to bring across solutions to the problems, because it's not just enough to tell the court it's a problem. You need to sometimes offer solutions as well. And we get solutions from all of these places that we can present to the courts. I'll leave it there.
Thanks, Christine. That's really interesting and really useful. Lisa, did you want to add a last quick comment, or does anyone else on the panel want to sort of say a last word or two before we close the session?
Just two quick things. Picking up on what Christine was just saying about how impacts cross borders, companies cross borders too. And in Africa in particular, in South Africa, we talk constantly about the fact that we have this dual positioning, in that we are both on the receiving end of environmental degradation and also the perpetrators of it, in the sense that there are South African companies causing havoc across the continent. And I think there's a very important role for regional instruments to play in that context. But then I think that instruments like the African Charter have a role to play outside of courtrooms and outside of legal arguments as well, in advocacy narratives. The one that what springs to mind is that in South Africa, our Minister of Minerals and Energy has a habit of saying rather disparaging things about environmental defenders, and has in the past, accused defenders of being agents of colonial elites from the global north and that kind of thing. And so in that sort of context, it's very important to control the narrative. And when your narrative is what we're trying to do is implement an African instrument, it's even more clear that when there are such spurious allegations made against you, that they're absolutely baseless. Thanks.
Thank you, Lisa. Alfred, I see that we have 2 minutes left in the whole session. Can you do a speed answer?
Well, I just want to make sure that that when we leave from this forum, that we are reminded about who a defender is, because sometimes we forget about that. There's a whole conceptualization, of a local chief or a local farmer or a local fisher folk or an indigenous woman, who's at the front line, who's actually doing the real work for us, as we all complain and yell about the climate crisis. It is these folks who are putting their life on the line and doing everything. The other thing also is that, even as lawyers, we shouldn't forget that the cases we bring that have framed the jurisprudence. When we talk about now a UN declaration on the right to the environment, who's informing that process? Who is behind that process? Who should be the face of that process? When we have legislation, at the domestic level, at the real, who's behind those processes? It is this environmental defender. But in our conceptual framework, when we see those who are the front line, it's like we feel these are the poor, miserable folks we've come to save. These are primitive and savage people who have nowhere to be there, especially from the lens of businesses. Why do they want to start an oil and gas operation that's going to develop an economy, build an infrastructure, create employment? Well, it was these defenders, most of whom are indigenous people, that told us centuries ago, do not cut down the trees, do not dig the earth and take out the well, because they knew it was a Pandora box. What did we tell them? They were savages and primitive, and we needed to civilize them. That civilization that we tend to impose upon them is what now has created this crisis. Now, all of us are now yearning for a right to the environment. They knew centuries ago, even before the science started off. So I just thought it's important that we have that image as we leave this forum to understand who are environmental defenders. They are the first responders in our firewall. It's now time to begin to respond, to protect and secure them. Thank you.
Thank you, Alfred. I think that's an excellent place to end this fascinating conversation. This has been an extraordinary panel. And I think the point about who defenders are, but also that the very concept of the environmental right of law is a concept that belongs to, is being made by, is the kind of product of the labor and knowledge and experience and lives of defenders is where we're kind of landing. And I think that we lose track of that in our discussion of it sometimes, and we really can't, because these are people who are putting their lives on the line. And who, as Alfred says, are the firewall. Thank you very much. I wanted to extend an big thanks to the organizers of this incredible event, both at UNEP and at the Asian Research Institute for Environmental Law. I know it's been an extraordinary amount of work. I can't even imagine what putting together a 24-hour event like this has been. It's been a wonderful process to be involved in. And then just a huge thank you to our panelists, to our commentators, to all of the audience who asked such exceptional questions, and just the sort of, just to note the importance of this conversation, the importance of how far we've come, the incredible things that have been achieved, but also the extraordinary amount of work there is still to do by and for and with defenders in the next 40 years. Thank you to everyone. Stay online for the next sessions.
Thank you so much, Dina. And once again, a big thank you to all of the panelists and the speakers. We are going to have the next session. The next session will begin on the hour. So between now and the next session, we're going to watch a video on the Montevideo Programme, particularly the 5th iteration of the Montevideo Programme, because today, the 31st of May, is the 40th anniversary of the Montevideo Programme. It's also a celebration of 50 years since Stockholm and all of the progress that has been made in environmental rule of law in these last 50 and 40 years. So we're going to watch a quick video about Montevideo Programme, and then we're going to start the next session on the hour. Our next session is in collaboration with partners from the Africa region, the Association of Environmental Law Lecturers in African Universities, the African Judicial Training Network on Environmental Law, and the Network of Montevideo National Focal Points in Africa. This session is going to look at partnerships to advance environmental law, and there will be French interpretation available in this upcoming session that will start on the hour. So please do stay, listen, watch the video, and we will welcome you back for the next session once the hour commences. Thank you again.